Welcome everyone to this presentation on an update to the recommended contract phrases form for the Bluegrass Realtors. My name is John Rompf, and I'm an attorney at the law firm of White, McCann and Stewart. I've had the privilege of working with both the Forms Committee and the Board of Directors on the development of an update to the recommended contract phrases form that I'm excited to share with you here today. Let me begin by letting you know that neither this form nor this presentation are intended to be legal or tax advice regarding any particular situation or real estate transaction that you may be involved in. I would encourage anyone that is watching this presentation to contact the appropriate professionals for any questions they may have about the use of these contract phrases in any particular real estate transaction that they are involved in. With that said, today I'll be walking you through the updated form and explaining the key changes. These revisions were made with three main goals in mind. First, we were hoping to address current developments in the marketplace and the needs of members of the Bluegrass Realtors as it relates to situations where they need recommended contract phrases to utilize in an addendum to the PSA. Next, we've tried to address situations where we've seen reoccurring issues or misunderstandings in negotiations or in how the contract plays out in the marketplace. And finally, we're attempting to improve this form based upon common issues that members have experienced and related to staff over the course of the past few years. The intent of this update is not to complicate your practice, but to simplify it by giving you some additional tools in the form of recommended contract phrases to protect both you and your client's interests. My goal today is when you leave this session, you understand what has changed in the form and that you're prepared to confidently use this updated tool in your work with your clients. I'd like to begin kind of by talking about one of the goals in all of these updates, and that is to try to standardize our forms as much as possible. To that end, some of the disclaimer language found in our forms has been updated with some common language aimed at, educating not only ourselves, but also giving us an opportunity to educate our consumers. And one of the big changes is really encouraging buyers and sellers of real estate to consult with tax and legal professionals about how a specific real estate transaction may impact them. So to get legal advice when necessary and to consult tax professionals early on in the process so they can make informed decisions with full knowledge of how the real estate transaction may impact their tax situation. The highlighted area on your screen is really just an example of this disclosure. And again, I would just encourage you to advise your clients to consult with the appropriate professionals to discuss their transaction on the front end, and particularly the use of any of these recommended contract phrases. Next, the disclosure is also a good reminder that I would not recommend altering any of these phrases without seeking independent advice about how those alterations may impact your particular situation. And the next thing that I kind of like to point out is one of the major changes to this form is actually what is not included. Many of you may have already taken part in another form update presentation, but we have decided to remove the kickout language from the recommended contract phrases. And the reason for that is we have developed a brand new form to handle kickout situations. And it was intentional to remove that language from this so that that process, when a buyer needs to sell property to close on a transaction and they've got a contingency to get that property under contract and they've got a contingency to sell that property, rather than having multiple ways our membership is dealing with those situations, we're trying to standardize one form to be utilized as much as possible to encompass all of those types of situations. So that language has been entirely removed from the recommended contract phrases form. And in lieu of that, you have a new tool at your disposal, a new form that hopefully you'll find beneficial. The next kind of thing that I like to discuss with you is this first section that should be highlighted on your screen about second contracts. This language really should be utilized in a situation where a contract is a second contract to an initial contract that has that kick-out clause language in it, or a contingency for the contract and sale of other property. So this will be a situation where you're the backup offer. And this language should be added to make it clear that the contract acceptance is contingent upon the cancellation of that first contract. So This would probably be most commonly utilized when seller has a contract that is got an immediate kickout and they wish to get released from that contract by entering into a new contract. And that new contract obviously needs to be contingent upon the release of that first contract because, as many of you probably have experienced in your careers, as these things can happen simultaneously with one another, it needs to be very clear so that a seller doesn't end up in a situation where they think they're under contract simultaneously with two separate parties. So it's really limited to those types of situations. The next phrase that we're going to address is the section highlighted on your screen having to do with situations where a purchaser's financing may be contingent upon the purchaser receiving funds from a third party. Normally, this probably comes in the form of a gift letter. And so again, this is not going to apply to all situations, but this language should be utilized in situations where a buyer's funding may be conditional upon the receipt of such a gift. And this is going to, take place in the form of an addendum being utilized to allow both parties to know that we've got a contingency for this gift, whether it's to make the financing work for down payment purposes or for debt ratio purposes, making sure that all parties are aware of that early on in the process. The next phrase is talking about a contingency that doesn't come up often with the proliferation of electronic signatures, but it has to do with situations where a contract has been partially executed by all the parties necessary, but additional signatures are required in order to make it fully enforceable. So, circumstances may arise, for instance, where one spouse may be out of town and not available, or all the heirs of an estate haven't been tracked down yet and haven't agreed, but you think you've got 9 of the 10 heirs and you want to go ahead and get the contract executed. So it creates a situation where you can go ahead, enter into a contract, have a contingent upon one more signature, and maybe buy 24 hours, 48 hours, whatever the parties can agree on in order to get that final signature so the contract can be fully enforceable. It should be utilized anytime that kind of contingency needs to exist, but it's obviously a very kind of specific circumstance. The next situation deals with circumstances where a proposed contract will be the backup to an existing contract specifically. And, there are 2 options to be utilized here. The first basically binds the buyer as the backup contract unconditionally. And this should really only be used in circumstances where the buyer is willing to make their backup offer and abandon their search for other new properties. The second option would be language that allows backup offers to be made and the buyer to continue searching for other properties and purchase opportunities while their offer is a backup and has not been, accepted by the seller as the primary contract. This is obviously probably the more common and normal circumstance where a buyer would want to be able to be a backup but continue to search and is under an obligation to notify the seller if it gets under contract on another property and wants to be released. The last phrase that I really want to talk about on page 1 has to do with replacement contracts. Again, this is something that has become a little more unusual given the proliferation of dot loop and the ease with which contracts may be modified or refined and edited, but it remains a useful language anytime the parties wish to replace an original fully executed agreement with a new agreement, and it allows for the ability to clearly document that the replacement contract voids the initial one and that this is their agreement. So again, it's becoming less common, but still a useful tool. Moving on to the second page of this new form, this next section is intended to use to comply with the requirements of KRS section 324.111, subsection 2. For those of you familiar with that subsection, which most of you probably are, this is where we need to get parties, buyers and sellers, consent and agreement to place earnest money, or what we call escrow, into an interest-bearing deposit account in order to disclose who would receive the interest on such account. So again, this doesn't always come up. A lot of folks don't use interest-bearing escrow accounts, or they rely on other parties to hold the escrow money for them. In the event you're using an interest-bearing escrow account and you need to comply with the statute, this is useful language to utilize. The next 4 sections on this page are all aimed really at the same thing, and that's protecting both you and your clients in circumstances where buyers and sellers are willing to enter into an agreement that waives certain due diligence and inspections. And this will allow all the consumers involved and the agent to be protected and understand that when they're making the decision to make offers or accept offers that have waivers of kind of normal due diligence found in the contract, that they're all doing so. They recognize kind of that it's not exactly the ordinary course of business of what's anticipated in a real estate transaction, but it's a course of action that they want to take based upon market conditions and making their offers more competitive, whatever the choice may be. But it's allowing this to be kind of recognized in writing by the parties. So I would recommend that if due diligence periods are being gotten rid of or certain inspections are being waived, that it's a protection really for buyers and sellers to use these phrases as a means of documenting that, so that if there's issues later on, it's clear kind of what took place. It's also a good opportunity for agents to educate their buyers and their sellers on the importance of these inspections while they're kind of included and outlined in our contract, our standard form contract. And if they're going to give up these rights, that, we're clearly documenting that they've done so. So the first one of these is the waiver of a right to a home inspection. Again, it's just to make sure the buyer fully understands that they're giving up this right that they have during the due diligence period, and they're electing to proceed without having the home inspected by a qualified professional. The next would be the waiver of an appraisal. Again, this should only be utilized when their financing isn't contingent on an appraisal, but it gives the buyer the right to not have an appraisal on the property and an opportunity for the agent to discuss what that means. And it also allows a toolkit for when buyers want to make their offers more competitive, or sellers want to counter offer. This waiver and appraisal gives some language to utilize in those circumstances. The next is a waiver of owner's title insurance. So when you watch the PSA update presentation, you'll notice that we've added some language about owner's title insurance, or an owner's opinion letter. But this is another opportunity for agents to educate consumers about the importance of obtaining that to protect themselves. But if they're not going to kind of document very clearly that they've been advised about the importance of it, and that they're going to give up that right. The last one of these kind of disclaimers, or kind of ways to advise our clients, is the waiver of a wood destroying insect inspection. Again, the PSA now kind of makes it the norm to really think of consumers gonna take this step, but I know that oftentimes buyers waive this and they choose not to, and so this is again just a way of utilizing an addendum to document that a party is decided not to do that and has decided to move on. So it's really an opportunity for agents to use a blank addendum to insert kind of these waivers as is appropriate. When folks are giving up their due diligence items, to really kind of document their informed consent to that when the buyer is kind of electing to proceed without obtaining such inspections or completing such due diligence. Moving on to page 3 of the form. This is something that I think has become more and more common as the world has become smaller and smaller. And it's to deal with situations where a potential purchaser has not actually personally visited the property that they're going to buy. So think of situations where you might have an out-of-state or just, person from a couple hours away who may be utilizing a local agent to set up a number of virtual showings or visits to open houses. And, the individuals who want to buy have not actually personally seen the property. I think this has become more and more common as, technology has allowed easy forms of communication for video teleconferencing, FaceTiming, those types of things, where people can see a property in pretty good detail without actually having to be physically present. Obviously, there's no substitute for actually walking the property yourself as a buyer, but realistically, sometimes that's difficult when you're relocating from 5 states away or whatever the circumstances may be. So this is language that can be utilized to basically waive the right to visit the property and kind of, hey, we're going to be buying this sight unseen, and that they've been advised about the importance of doing so, but they're giving up that kind of right to see the property. The second option is basically making the contract contingent on that personal examination of it. So it's kind of acknowledge, hey, we haven't seen this property and we've got X amount of time in order to do that, and sets kind of definite deadlines for when that is going to take place, and allows it to be clearly contingent upon the prospective buyer's visit. That really concludes this presentation of the kind of changes and alterations to the recommended contract phrases. I want to thank you for your time today. I hope this information proves to be helpful and useful to you as you assist your clients. And again, I thank you for your time and wish you the best of luck and success in the coming year.